Okay, thank you, members, and I declare the meeting now open to the public online. Can I welcome all of our members who are participating by video conferencing today, and also remind members about the protocols regarding the use of electronic devices. So our first item today then in public session is our Health and Social Care Bill, the formal clause by clause consideration of the Health and Social Care Bill. I refer members to your papers there at tab 1 of the pack, and I would ask do members wish to declare any interest, and I will declare my own interest of having worked in a social worker and being on a leave of absence career break from one of the health care or one of the trusts. So any other interest, members, to declare? No, thank you. So, members, I will proceed through the clauses and put the questions formally, but I would like to first of all ask the clerk to read the committee's agreements arrived at. So go ahead, please, clerk.
Thank you, Chair. Just to read into the record the amendments that the committee's agreed. So they've agreed to Amendment 1, which is a new clause for a new model. And after Clause 1, insert new model for health and social care. 1A, Part 1, the Department must, before the first anniversary of this Act coming into operation, lay before the Assembly Regulations 2A, establish a new model for the planning, management and delivery of health and social care in Northern Ireland, and B, set out the governance and reporting arrangements for the new model. Part 2, if it's not reasonably practicable for the Department to comply with Section 1A1, the Minister must make a statement to the Assembly on why it's not reasonably practicable to do so. Part 3, regulations under this section are not to be made unless a draft of the regulations has been laid before and approved by a resolution of the Assembly. Then Amendment 2 is the repeal of the local commissioning groups. And Clause 4, page 2, line 14, at the end insert Part 4, the Department may by regulations repeal Section 9 of the Health and Social Care Reform Act, Northern Ireland 2009. The regulations provide for under Section 4.4 must not specify a date which is earlier than the date on which the regulations provided for under Section 1A of this Act are approved by a resolution of the Assembly. Part 6. The regulations provided for under Section 4.4 are not to be made unless a draft of the regulations has been laid before and approved by a resolution of the Assembly. Part 7. Regulations under Section 4.4 may make such amendments to the Health and Social Care Reform Act (NI 2009) as this Act as are necessary or appropriate in the consequence of the repeal made by the regulations. And then finally, Amendment 3 is in relation to continuation of the local commissioning groups. So in Schedule 1, page 5, line 3, in paragraph 11, leave out and B. Schedule 1, page 42, line 35, in paragraph 232, leave out 7 to 11, insert 7, 8, 10 and 11. Schedule 1, page 42, line 35, at the end insert 232A in section 9.1. A, for the regional board, substitute department. B, omit in accordance with paragraph 7 of Schedule 1. 232B, in section 9.3b, for regional board may with agreement of department substitute department may. 232C, omit section 9.6b. 232D, omit section 9.7. Then Schedule 1, page 42, line 37, leave out and local commissioning groups. Schedule 1, page 42, line 38, leave out paragraph 233B. Schedule 1, page 42, line 39, leave out paragraph 233C. Schedule 1, page 43, line 38, leave out and local commissioning groups. So that's the amendments that the committee's agreed to.
Okay, thank you, Clerk. So members, I'll proceed through the clauses and put the questions formally, and I advise members that where there are amendments, I will put the question on the amendment first. If there is not consensus on the questions, I will ask members to vote through a show of hands, and the Clerk will confirm the result of each vote. So members, moving to, first of all, Clause 1, Dissolution of the Health and Social Care Bill. So, is the committee content with Clause 1 as drafted? Committee content.
Agreed.
Thank you. Committee are content. The committee is content with Clause 1 as drafted. So, moving then to new Clause 1A, new model. So, is the committee content with clause 1A as drafted for the committee by the Bill Office?
Agreed.
Great, thank you, members. So the committee is content with clause 1A as drafted. Moving on then, members, to clause 2, which is transfer of the regional board's functions. Is the committee content with clause 2 as drafted?
Agreed.
Great, thank you. The committee is content with clause 2 as drafted. Moving on to clause 3, which deals with schemes for the transfer of assets and liabilities. Is the committee content with clause 3 as drafted?
Agreed.
Agreed, thank you, members. The committee is content with clause 3 as drafted. Moving on to clause 4, transitional provision, amendment on the repeal of the local commissioning groups.
Sorry, Chair, it's just on that one. There is an amendment on that. It's not in the brief there.
Okay.
So we'll put the question on the amendment first.
Okay, and
Is the committee content with amendment 2 to clause 4?
just show me that on the brief there.
Apologies, I've missed that out, Chair, on the brief.
Yeah, so is the committee content with amendment 2 to clause 4?
Agreed.
Yep,
As amended.
as amended.
No, just content with amendment number 2, and then we put the question
Okay.
content with clause 4 as amended.
Okay, so are the committee content with amendment number 2 to clause 4? Content? Thank you. The committee is content with amendment 2 to clause 4. So I then go back to
So the question is content with clause 4 as amended.
is the committee content with clause 4 as amended?
Agreed.
Agreed. The committee is content with clause 4 as amended. Thank you. So we're moving on then, members, to clause 5, which is interpretation. Is the committee content with clause 5 as drafted? Content, thank you, members. The committee is content with clause 5 as drafted. Clause 6, which deals with commencement. Is the committee content with clause 6 as drafted? Content. The committee is content with clause 6 as drafted. Clause 7, which is the short title. Is the committee content with clause 7 as drafted?
Agreed.
Agreed. Thank you, members. The committee is content with clause 7 as drafted. So moving on then to schedules. Schedule 1 is the transfer of the regional board's functions and amendment on the continuation of the LCGs. So is the committee content with the amendments as drafted for the committee by the Bill Office? Content? Members are content. The committee is content with the amendments as drafted. So is the committee content with Schedule 1 as amended by the committee? Content? Thank you, members. The committee is content with Schedule 1 as amended. Moving on to Schedule 2, which is the transfer of assets. Is the committee content with Schedule 2 as drafted?
Agreed.
Content, thank you. The committee is content with Schedule 2 as drafted. Schedule 3, transitional provision. Is the committee content with Schedule 3 as drafted? Yep, committee content. The committee is content with Schedule 3 as drafted. The long title then. Is the committee content with the long title of the bill?
Agreed.
Committee content. And the committee is content with the long title as drafted. Members, that concludes our formal clause-by-clause consideration of the bill. In order to agree the committee's final report at next Thursday's meeting, the committee will need to have a short meeting next Tuesday to consider the draft report. Are members content to schedule a short meeting for Tuesday lunchtime? Yep, agreed, thank you. Okay, members, thank you for that. So moving on then, members, we have apologies this morning from Paula Bradshaw and Leah Flynn. Are members aware of any other apologies? No, all other members are attending. So members, Leah Flynn has advised the clerk in writing that for this committee meeting she's delegating authority to Carol Nichillen to vote on her behalf. So moving on, members, then to chairperson's business, I just want to note the Autism Bill passing a second stage and departmental consultation in the Assembly this week. I also want to just refer to the all-party group on cancer met, and I have to say, and it's in keeping with what many of us are hearing, worrying figures around the issue of cancer surgeries, and I think that is again a call to everyone to do all they can to look after themselves, look after their families, and also protect the healthcare system, which is under tremendous pressure, probably unprecedented pressure at this particular time. In light of that, members, we did agree to do a joint statement with the Minister to indicate our concern at the present situation and to call on everyone who is able to take a vaccine to do so, to protect themselves and to protect their families. And I think it's important that we make it very clear to staff on the ground that we fully understand the amount of pressure that they are under. I think it's important that we also see that meeting take place that the committee called for last week among the representative bodies and the unions and others to ensure that everyone is doing everything they can to support staff and to move the situation forward. And I have to say, I've spoken to a lot of the relevant bodies and indeed the Minister, and I am pleased that the Minister has made some announcements recently which do take some of the proposed solutions forward, and I think that's welcome, and clearly much more to be done, and the committee, I think, will stand ready to play our part in all of that and do anything we can to assist in that effort. So thank you, members. Moving on to the draft minutes then, I refer you to the draft minutes of the meeting of the 16th of September at tab 4.1. Are members content with those minutes? Yep, content, thank you. Moving on then to matters arising. There is one item under matters arising. I refer members to the clerk's memo at tab 5.1 in relation to the proposal made by Jerry Carroll at last week's meeting regarding the pay proposal for healthcare workers. Two members have proposed amendments are included in the pack. Members, as both of those amendments are amending the same paragraph, I propose that we take the amendments in order of which they were received by the clerk. So we will take Carroll's amendment first in that case, and if that amendment is agreed, I will then put the question on the proposal as amended. If agreed, no further questions will be put. If Carroll's amendment is not agreed, I will ask the question on Pam's amendment. If that amendment is agreed, I will then put the question on the proposal as amended. If agreed, no further questions will be put. If Pam's amendment is not agreed, I will then ask the question on Jerry's initial proposal. Are members content with that approach? And I would then just like to ask the clerk to read the amendments. No, well, actually, I'll just check with members first of all. I'll come back to that. I'll check with members first of all. Are members content with that approach broadly? Or any comments? Alan, go ahead.
Yes, Chair. Just I hear what you're saying, but can I clarify? Is it open to a member at the conclusion of this to put a proposal on the floor in relation to broadly the same sort of topic, or are you saying that we only have the authority to vote on those two amendments and then it's closed shop after that? I'm just wondering about is that position supported by standing orders? I don't know the answer to that. I'm just asking the question.
Okay, thank you, Alan. I'll go to Jerry.
I want to speak to the amendments, Chair, as well after, but just on that point, I mean, this is the third week we have discussed this. I think there was a call last week for amendments, and I'm presuming they came in Monday or Tuesday, I presume. So I'm not opposed to amendments, but it is getting a bit absurd that we've spent 3 weeks talking about this, and I would like to get a resolution, hopefully support the proposal.
Well, in relation to standing orders, my understanding, Alan, is that the committee can make a decision as to what to do. I actually think that there has been a fair opportunity presented to members now across a couple of weeks to provide amendments, and in order to move the situation on, it's entirely up to the committee. You know, I actually think we should deal with the amendments that have been submitted and members have had a chance to look at and consider. That's the approach we've taken. But any other thoughts from members in relation to that? Carol, are you indicating there? I wasn't sure, you went off my screen again.
Me, sir? No, Chair.
Yep,
I wasn't.
Okay, so
Sure.
Go ahead, John.
I think it is a fair way forward. At the end of the day, we said about we couldn't consider last week because it's a serious subject and people did have concerns around the wording. People were given the opportunity to supply an amendment. Some did. And I do believe that, hopefully we can find an agreement. But in the event that we can't and there is other parties, there's other means by which you can bring a motion before the House in relation to this topic. So just to put that out there, I do think it's important that we are given the opportunity to consider the amendments which were produced, because what the purpose of this is to essentially agree a committee motion. And if we're not in agreement for a committee motion, there is other means by which you can bring it to the floor of the House. So I would be in agreement to follow the proposed path that you've suggested.
Any other thoughts on that before we move on to the discussing amendments? Our members broadly agree that we take the amendments that have been provided and that members have had an opportunity to look at?
Chair.
Yes, Pam?
Yeah, thanks, Chair. I think just on this particular circumstance, because it has gone on for a couple of weeks, I think that is appropriate in this situation. So I'd be happy enough with that form of action this morning.
Yeah. Okay, members, I think we have broad agreement, I think, from the committee to proceed on that basis. So then in terms of, do we discuss each of the amendments, or do we have a general discussion now in relation to?
I think if members are happy, I'll read out the amendments just into the record, and then we can have a discussion and then go through the process that you outlined of putting the questions at the end of that discussion.
Yeah, okay, thank you. So go ahead then.
Thanks, Chair. Carol Nacullion has proposed to remove the last paragraph and replace with the following: that this committee calls on Minister Swan to engage with the health unions in relation to a fair pay uplift for all health and social care staff, and further calls on the Executive to seek the increased funding necessary from the British Treasury. Pam Cameron has proposed again to remove the last paragraph and replace with the following: that this committee calls on Minister Swan to engage with the unions and professional bodies in relation to a fair pay award, and implore the Executive to explore ways to fund a more substantial pay uplift for health and social care staff, which they are fully deserving of.
Okay, so Carol, do you wish to say anything in relation to that amendment before we go to committee members?
Yeah, Chair, thank you. So, I mean, on the face of it, people could argue there's not much difference between my amendment and Pam's. I literally wanted to add the British Treasury in, because even when Minister Swan was in the Assembly this week, and he still spoke about Barnett Consequential, and that's only in relation to health and social care, we need an additional uplift, because everyone feels that the pay awards that staff are due isn't cutting it with the current offer. So, and again, I didn't omit professional bodies deliberately. I just assumed that health unions are staff side representatives as well. So it's just to get that on the record. But on the basis that I want to maintain and vote on my amendment is that I believe that the money that's on the table at the minute just isn't enough. We're in a health crisis. We're in a health crisis before the pandemic, and we're certainly in one now. And I think what we need to do is empower the Executive to seek additional funding from the British Treasury, in addition to the proposed Barnett Consequential, which is only in relation to social care. So thank you, Chair.
Okay, thank you. And I'll take other members' views. Just who?
Jerry was wanted.
Jerry, go ahead.
Yeah, thanks. Just speak to the motion and the amendments, Chair. Yesterday, obviously, the Minister talked about the tough winter period ahead we're entering into, and retention of staff, and I think the joint letter from yourself and the Minister referred to that too. The past few weeks, I've been speaking to probably hundreds of health workers outside hospitals and communities, and they are pretty aghast at the 3% pay offer. given the fact that obviously it doesn't represent what they're demanding and what they're calling for. And on top of that, inflation is set to rise above 3%. The National Insurance contribution increase, universal credit uplift being abolished, car parking charges reimposed for health workers. So they feel like they're being hammered, and this pay offer is another example of that. And to be frank, I think honeyed words from the Minister or anybody else won't cut the mustard about thanking them. They need proper pay deals. And my point is that if there's not a proper uplift above the 3% now, then it's not going to come at some distant point in the future. And just to speak to the amendments, I mean, in isolation, I have no issue with them, but my problem with them politically is that it removes criticism of the executive and action to writing towards the Minister of Health and the First and Deputy First Minister. So I'm for putting all the pressure possible on the British Government, and the original proposal actually refers to that in passing, but in the end of the day, if there's no money forthcoming from the Tories, then it'll be the executive that's going to implement the 3%, and there has to be a criticism of that. And they will be implementing the 3% pay offer. So for those reasons, I'm against both the amendments, and I want to just support and speak to and move the proposal that I drafted last week.
Thank you, Jerry. And Pam, then, do you want to speak to your amendment as well? Just waiting, we might have lost Pam on the line there. Pam, do you wish to speak to your amendment there now as well?
Thanks, Chair. I think really it's self-explanatory. I don't feel like I can support Jerry's amendment as it stands, so I would hope that I could have enough support for my amendment to see that go through. But I think it is self-explanatory. I think we all want more for nurses. I think we would be realistic in this, but we certainly wouldn't want to be talking around a motion which is asking us not to give any rise to our national health staff. So I think we would need to be very careful around that, but I would hope that the members could support the amendment that I've made to the motion today. Thank you.
Thank you. And I suppose I want to say on my own behalf that I would be, and I said this last week, I would be uncomfortable with us taking a position that would actually block, in effect, as worded, would block a pay rise to staff. I think it's also important that we recognise that the British Government do have a responsibility here, and that I think unions recognise that. But at the end of the day, I believe and I do trust in unions' ability to negotiate and to make a decision on whatever pay settlement is put before them. But I would be concerned that in some ways it could actually even undermine their call, which still is outstanding, on the British Government to step up to the mark and to fund health workers. We will also have the additional problem of social care workers and that integrated element here. And we're in a situation where there is finite resources here, and following a period of cuts and austerity to health services. So I would not be comfortable with us blocking a potential pay rise to workers, certainly. So any other thoughts, members? No. Okay, members, I'm going to move then to the votes. So first of all, yeah, who's on the queue? Alan, go ahead, Alan.
Sorry, Chairman, I had raised my hand. Just in relation to Jerry's original proposal, when you read it, that last paragraph, and you set it against the two amendments, as you have pointed out, the only real difference is the fact that Jerry is asking us to block and call on the executive to block the 3% pay rise that Minister Swan is hopeful of being able to deliver for nurses. And I think that would be seen as doing a disservice to nurses, and I think it would send out really the wrong signal. I mean, we have been backing our medical staff all along the line, and I just think this would be the wrong message to try and block that 3% increase. The thing about the 3%, the Department of Health, I understand that they had budgeted for a 2% increase, and then Minister Swan had looked at what the review panel had said, and he was seeking then to amend that 2% to 3%. And I understand that he has made a request for money through the October monitoring round to make up the shortfall, to bring it up to 3%. And that figure that he's asking the Minister of Finance for is something in excess of £50 million. And for each 1% of an increase we give, it's going to cost the executive £20 million. So I'm just wondering, in terms of both of the amendments, we're not really spelling out what we think is a fair offer. You know, we're even very ambiguous. So, you know, if the minister came back and said 4%, would we be happy with that, or do we want it to be 6%? Or, you know, I would be more happy if we were to actually, you know, put on the table and put on the record what we think is a fair offer that we could support, and that we'll not be coming back with more letters to the executive going forward. So I'd like to hear some thoughts on what you know, the committee feels would be a fair offer. My own position, and I'm sure there's not anybody on the health committee that would disagree with us, you couldn't pay the nurses enough. That's just the bottom line. The work that they've been doing and the work that is going to be expected of them during the next 4 or 6 months is phenomenal. And money just couldn't pay you for what we're going to ask them to do and the sacrifices that we're going to ask them to make. So, I mean, if the executive decided on 12% and to meet the fullness of the union's demands, I would be right out there supporting it, as I'm sure every one of us. You know, there are practicalities around that, but just has anybody any thoughts on that? What would be a fair offer to the nurses? Thank you.
Well, first of all, I'm going to go to Ciara, and then I have an indication from Jerry. So, Ciara, go ahead, please.
Thank you, Chair. Say to Jerry, proposal forward. I was for that part of the meeting, so just to say thank you for bringing this forward. I will be supporting Carl's amendment this morning, just on the basis that I think it's important to include pressure on the British Treasury because the current funding really isn't sufficient, so that's really important to highlight. And I agree with Alan's statement, we really couldn't pay our nurses enough. I suppose a conflict of interest, my mother's a nurse, so I just know from a personal perspective how hard that they work, so I'll be supporting Carl's amendment this morning. Thank you.
Thank you. Jerry?
Yeah, just 2 quick points. I mean, Alan's talking about blocking a pay raise, but this isn't a pay raise. This is an offer that's below inflation, so that has to be nailed. And a fair offer, in my opinion, would meet the union's demands, and they've got different demands because they're different trade unions. But if we're really to value what they have done and what they represent, then we should respect their calls. And 3% is way off that demand. I mean, claps, you know, are great, but when it comes to the crunch, people have to be paid a fair wage, and this offer doesn't represent that. And Alan said you couldn't pay them enough, but he's willing to accept a motion that doesn't reject or criticise or oppose a 3% pay offer. So there's a fundamental contradiction in that statement and the actions behind it. And yeah, so I think they are deserving of more than a 3%. They are deserving of a hell of a lot more. That's why the motion is here. So I think that makes sense. And there's a contradiction in what's being said here. Thanks.
Okay. Any other indications there from members? I think everyone has had their view expressed on this. So I'm going to move then to the amendments. Clerk, do we need to read each of those individually in, or is there good enough understanding? I think we've had it clear, and I think it's very clear. Members have looked at this. So I'm putting Carol's amendment first. So all those in support of Carol's amendment to the motion.
So Carol holds Orlea's as well, so that's 4. So okay. It's Colin, Carol, Orlea and Cara.
Yep. And those against?
And it's against are Jerry, Alan, Pam and Jonathan. So that's a 4-4 split, so the amendment doesn't carry.
Okay, the amendment doesn't carry. Thank you, members. I will then move on to Pam's amendment. So all those in favour of Pam's amendment?
Okay, so that's Jonathan, Alan and Pam. Okay.
All those against Pam's amendment?
So again, Carol has Orlea's vote. So that's 3, 4 and 5 against.
Okay, so that amendment doesn't pass?
Yep.
That amendment falls also. So then I'm putting Jerry's motion as proposed by Jerry. All those in favour?
Okay, so it's just Jerry.
And those against?
Okay, so it's the rest of the members.
Okay, members, thank you. That concludes that section, and we're moving on to section 6. And I propose we'll take a very short comfort break there, just a 5-minute break, maybe, members, and we'll come back to adoption and children's bill. Thank you.
This is the Northern Ireland Assembly Senate Chamber Programme Sound. This is the Northern Ireland Assembly Senate Chamber Programme Sound. This is the Northern Ireland Assembly Senate Chamber Programme Sound. This is the Northern Ireland Assembly Senate Chamber Programme Sound. This is the Northern Ireland Assembly Senate Chamber Programme Sound. This is the Northern Ireland Assembly Senate Chamber Programme Sound. This is the Northern Ireland Assembly Senate Chamber Programme Sound. This is the Northern Ireland Assembly Senate Chamber Programme Sound. This is the Northern Ireland Assembly Senate Chamber Programme Sound. This is the Northern Ireland Assembly Senate Chamber Programme Sound. This is the Northern Ireland Assembly Senate Chamber Programme Sound. This is the Northern Ireland Assembly Senate Chamber Programme Sound. This is the Northern Ireland Assembly Senate Chamber Programme Sound. This is the Northern Ireland Assembly Senate Chamber Programme Sound. This is the Northern Ireland Assembly Senate Chamber Programme Sound. This is the Northern Ireland Assembly Senate Chamber Programme Sound. This is the Northern Ireland Assembly Senate Chamber Programme Sound. This is the Northern Ireland Assembly Senate Chamber Programme Sound. This is the Northern Ireland Assembly Senate Chamber Programme Sound. This is the Northern Ireland Assembly Senate Chamber Programme Sound. This is the Northern Ireland Assembly Senate Chamber Programme Sound. This is the Northern Ireland Assembly Senate Chamber Programme Sound. This is the Northern Ireland Assembly Senate Chamber Programme Sound. This is the Northern Ireland Assembly Senate Chamber Programme Sound. This is the Northern Ireland Assembly Senate Chamber Programme Sound. This is the Northern Ireland Assembly Senate Chamber Programme Sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme.
Okay, members, thank you, and welcome back to our resumed meeting here. We're moving on to item 6, which is the Adoption and Children Bill. We are, first of all, taking a briefing from the research organisation RAISE, are going to provide a briefing. So it's on the background to the Adoption and Children Bill, which was introduced in the Assembly on Monday, the 20th of September. I refer members to the research paper, which is a tab 6.1 of your pack. I now would like to welcome Dr. Leslie Ann Black from Research and Information Services. Good morning, Dr. Black. Can you hear us okay?
Good morning. I can hear you well and clear. Can you hear me okay?
Yes, we can, loud and clear there, Leslie Ann. Thank you very much. So, Leslie Ann, I'll just ask you then to go ahead with your briefing, please.
Thank you very much. Thank you, members. It's great to be here this morning. This presentation will provide members with a brief overview on the complex area of adoption, how it affects children and families, as well as the lengthy waits that can be incurred during this process. I'll briefly highlight the current legislative context for adoption and a few points that may set the context of the bill before it proceeds in more detail. The need for adoption reform began about 15 years ago, and just this week, the Adoption and Children Bill has finally been introduced into the Assembly. This is very welcome news. Adoption is the legal process by which a child or their siblings who cannot be brought up within their family become permanent legal members of a new family. It's a complex area of the family law which involves multiple stakeholders, and they often have competing interests. The key legal framework for adoption is currently the 1987 Adoption Northern Ireland Order, and that should be read alongside the Children Order, which deals with the care and protection of children living in Northern Ireland. Page 5 of the research briefing outlines what the current adoption law does and the wide range of legislative provisions, regulations and international conventions that link to child welfare and the impact that this can have on the adoption process. It is very much worth noting that the adoption legislation is 34 years old and very much in need of reform. A really important point to highlight is the changing profile of children who are in need of adoption. In the past, most children who were adopted were orphan children or young babies born out of wedlock. Today, the vast majority of adopted children come from the care system, and many people aren't necessarily aware of that. Most will have been removed from their families to protect them from significant harm, neglect or abuse. Few, if any, will be babies. Many children will have had significant needs to support them from the trauma they've experienced, and some may have disabilities or fetal alcohol syndrome that will require long-term management throughout their life course. There are also other groups of children who are currently adopted, and these include children adopted by a step-parent and a birth parent, and an even smaller number of children are adopted from other countries, and we call this inter-country adoption. That type of adoption is more complex, I would say, in terms of having to deal with international statutes and other state laws. It can also be far more expensive. The number of inter-country adoptions is relatively small. There's only been about 5 in the last 5 years. As shown in the briefing paper, the number of children being adopted has declined since the 1970s, when in a given year you could have had maybe 500 children adopted. In the last 20 years, there's been between about 100 and 150 children adopted in a given year. Last year, for example, there were 125 adoptions in Northern Ireland. Of these, 111 were looked after children, 13 were step-parent adoptions, and 1 was an inter-country or overseas adoption. Because adoption is a lifelong commitment, it really requires serious thought and preparation, and the assessment process, we know, is rigorous. Adopters can be anyone over the age of 21. They can be married or unmarried couples. They can be single, people with different sexual orientation, people already with children or without, people with disabilities, and those from any religious or ethnic background. So concentrating on the majority of children adopted, that is, children who enter the care system, they're known as a looked after child, and the government states that it is committed to helping these children remain with their families in all but the most exceptional of circumstances. But when a child becomes a looked after child, the trusts assume a corporate parent role and are responsible for safeguarding and promoting the child's welfare and well-being. Over the last 10 years, there's been about a 30% increase in the number of looked after children in Northern Ireland, and there's over 3,000 in the system at the moment. We know that some looked after children will experience successful outcomes, but overall as a group, their life outcomes and life chances, especially regarding health and education, tend to fall significantly below that of the general population. I think data from the department shows around 57% or so of children will have some sort of special educational needs provision. These looked after children will also experience different care journeys. Some will stay in care briefly during a crisis before returning home, whereas others spend periods of time re-entering care, and sadly some will spend very long periods of time in care. This care can take many forms and placements, such as formal kinship care or residential care, before a more permanent way forward is found. Last year, around 80% of all looked after children were placed in foster care, and for those leaving care, 50% returned to their families, and only around 12% were adopted. It's important to stress, though, that adoption isn't suitable for every looked after child, and as the figures show in the paper, but if adoption is decided as the plan going forward, which is known as a best interest decision, trusts must follow a range of statutory processes. And this is because simply adoption is one of the most serious interventions a court can make in a family's life. The research indicates that the earlier a child is placed into a permanent placement, the more likely that is to succeed. However, it takes on average 3 years for the adoption process to complete in Northern Ireland. Evidence suggests this is much slower than in England and in Wales. Formal targets to place a child for adoption within the 3-year time period have been set by the Health and Social Care Commissioning Direction, but these targets are being repeatedly missed year on year, as is described in the paper. So, for example, for 2019-20, only 57% of adoptions occurred within that 3-year time frame, and the target is that 90% should be achieved within that 3 years. Whilst we want these children to be matched with the right families and the due process that goes along with that, these lengthy waits are likely to have a serious and detrimental impact on children who desperately require that family stability. It must also be very exasperating for prospective adopters waiting and wanting to have permanence for that child. The paper also highlights the important role of adoption agencies and the services they provide, both for adoptions that take place at home and from other countries, and also the various roles that the agencies will have in assessing potential adopters. Although these agencies will try to place siblings together, it can be quite difficult. The data suggests that about nearly 40% of adoptions last year were in sibling groups. There's also a database called ARIS, which can also help match these children with prospective adopters. Applications for adoption are considered by the adoption panel, and they will decide whether this is in the best interests of the child and whether an application should be made to free a child for adoption. And this essentially means that the courts can decide if the child is to be adopted with or even without their parents' consent and agreement. As only a small number of children are adopted with their parents' consent, this often leads to highly lengthy, costly, protracted court cases. So on the one hand, there is the balancing of the rights of the birth parents, for example, their human rights to family life within Article 8 of the Human Rights Act. And on the other hand is the balance of the best interests of the child. And we know that this is paramount, and probably the department will come and talk a lot about this when they meet you. Difficulties also arise in relation to what level of parental contact will be had with the child. And once the adoption order is granted, the courts must decide this. A number of other factors can also cause delay in the adoption process, not just about recruiting and matching prospective adopters, but meeting the needs of some of these extremely vulnerable children. There's also probably very considerable pressure on social workers trying to demonstrate proportionality when struggling with the existing tensions that do exist. And we know that delays also exist because of the way that the courts have their processes at present. They might request additional information, and we also know there might be issues with resources such as staffing. Once an adoption order has been granted, the state will sever all legal ties with the child's natural parents and give those rights and responsibilities to the new family. This decision is irreversible. So in terms of the background to the bill, the reform, as I mentioned earlier, has been underway for 15 years, and the timeline of these set of events is highlighted in the paper. To briefly recap, in 2004, the department first asked for the views on the proposed adoption legislation. By 2010, draft proposals for a new adoption and children bill were agreed by the executive. Following this, both in 2011 and 2014, health officials briefed the Committee for Health on the proposed bill. Delays with consulting with the bill meant that it was not introduced within those mandates. A new consultation finally ran in January 2017, and as part of this exercise, the views were sought on the proposals for the legislative reform to both adoption and to children's legislation. The views of young people were also sought. That same year, a draft bill with 140 clauses was produced alongside an impact assessment, explanatory notes and a children's version of the consultation. Then we had the collapse of power sharing. more recently, the Minister has confirmed that the 27 version of the bill has been substantially amended, and a new draft bill called the 2021 version, just for my own purposes, has been published. As we can see, there are now 160 clauses, and the consultation responses that happened in 2017 have now finally been published on the Department's website, and it shows that there were 71 responses to the bill. And overall, there was good support for the proposals. There are many clauses to consider, and some of the main provisions are outlined on page 17 onwards of the briefing paper. But broadly, the bill looks to be a very welcome and positive step in the right direction for these very vulnerable children. As we know, the key aims of the bill are to modernise adoption law, to mend the Children's Order, and to place the needs of the child at the centre. There will be a range of prescribing powers, new processes for adopters, new ways of working for adoption agencies and courts, and different review mechanisms. It's also intended that this process will become more efficient and reduce delays. For example, getting courts to draw up timetables for resolving cases and maybe dispensing with parental consent earlier in the process. Other positive aspects of the bill are to create a right for adopted children and adoptive parents to request an assessment of the needs for adoption support services. And there's also going to be a duty to promote educational achievement of looked after children and the introduction of special guardianship orders which could support older children who do not wish to extinguish that legal link that they have with their birth parents. And moving forward, it would be good to hear from the Department about how some of the finer details of the bill will be worked through, maybe what they consider to be the most complex and controversial. It's also anticipated that further consultation will be required to inform the regulations associated with the bill. And finally, although I didn't really include it in the paper, there is going to be a cost implication for the bill, around 14 million in the first year and around 12 million of recurrent funding in years 2 and 3, with additional monies required for staff to make these changes. I know I've taken up far too much of your time. Thank you for your attention. I'm by no means an expert, but I'd be happy to take any questions or comments. Thank you.
Thank you, Leslie-Ann, and not at all. Actually, that was very, very useful, I have to say, in what is a hugely important but complex area. And I will declare my own interest as having worked previously as a social worker and worked indeed with looked after children and families and foster and adoptive parents. And there is a huge levels of complexity. There's no doubt about that, and we will certainly, I think, get into some of the questions around that today and as we move forward through what is in itself a complex bill dealing with a complex area. Can I ask you, just from a research point of view, have the kind of fundamentals of this bill been drawn upon from other places that have done something similar, and has that given an opportunity to look at what the impacts or outworkings, or is this quite a bespoke new approach for here in general?
I think, Chair, much of the bill will have taken learnings from other jurisdictions nearby. For example, I think special guardianship orders have been drafted and based on England and Wales possibly. I think because our legislation is in so much need of reform, we have plenty to learn from those other jurisdictions, and they will be far further ahead of the game than us, so to speak, in terms of what we can learn. For example, in terms of those special guardianship orders, I think the views are mixed on that. So in going forward, it will be worthwhile and useful to see what other jurisdictions can impart to us as we go forward to try and develop the right kind of legislation to meet the needs of these children.
Thank you. And the second one then from me is and you have touched upon there the conflict of interest and the complexity around the rights of birth parents versus the rights of the child, which must of course always be central, but also versus the rights of potential adoptive or foster parents. And in your view, you know, in terms of then going forward from that into the transparency of the process and the, you know, the right to appeal and the right to be involved in the process, have you any thoughts on that, just in terms of from a best practice point of view?
I think it's a very good question. I I wouldn't want to give any personal opinions, but I think all voices need to be heard in this really complex issue. Of course, the child will always be at the centre, but there are very important stakeholders, both on the birth side and on the other side of the prospective adopters. So yes, it's my hope that that will be played out within this bill, that those voices will be very much heard, not just from the children's perspective and maybe the voluntary organisations that represent them, but very much from families who have maybe experienced this or are going through this, and both sides of that coin.
Okay, thank you, Leslie Ann. So I'll go to members' questions now. I'm going first of all to our Deputy Chair, Pam Cameron, and then I'll go to Cara Hunter. Go ahead, Pam, please.
Thanks, Chair. Thank you, Leslie Ann, for your presentation. It's very useful to have. Leslie Ann, first of all, you'd talked about the cost implications of the bill. If it was £14 million in the first year, what were the other two figures you'd given me?
Sure, Pam. Sorry, it's 12 million in years 2 and 3, with additional monies required for staff. So there will be definitely cost implications there.
Okay, that's great. Thank you. Okay. And the other thing I wanted to ask you, Leslie Ann, was in around, and you'd mentioned educational underachievement. And I'm just wondering why. And obviously, yes, we are behind everywhere else in dealing with this legislation, but to some extent that could be a good thing, because we can take on board the learning from the other jurisdictions and hopefully get this very right, because it's very long overdue. So appreciate that. But do you know why there was a decision to include, those types of issues around educational underachievement, within this particular bill, and why it wasn't maybe, considered for a standalone bill around children and themselves? Do you know why they've decided to include it within this adoption bill?
I'm not sure exactly why they would have decided this is the place for it, but we definitely know that so many of these children are affected, so it seems a perfectly appropriate place to put provision in, because 57% of these children will have some sort of a need or a SEND statement. So and we know that they are so disadvantaged, not through their own faults by any means. It's just the vulnerability of what has happened to them through no fault of their own. So it's very welcome, I would say, and I would just point you more in the direction of the department when they come to check with that, if that's okay.
And I will check with them, Lisanne, just to get your opinion. And do you know, is that included in any other legislation elsewhere in other jurisdictions?
I'm not sure, actually, but I will go ahead and find out for you and get back to you, if that's okay. That
would be great. Thank you very much.
Okay, thank you.
Okay, thank you, Pam. And going then to Cara. Go ahead, Cara. Lanare, Lidahull.
Thank you, Chair, and thank you very much, Leslie Ann, for being here this morning. I found your brief very helpful. I have a question similar to Pam's. It was just around educational underachievement. It's okay if you don't have the answer. It was just around, within this bill, is there any discussion around educators liaising with social services to perhaps hear more about why a child may have behavioural issues or any kind of complex needs, and also what further support will be available for adopted parents post-adoption through this bill? Thank you.
Okay, first question, I think I'll let the department answer that, because they'll know exactly who's been involved in those discussions. But I'm sure there has been, over the past number of years, a lot of discussion with all those interested stakeholders. Regarding further support, one of the brilliant things about this bill is that it's going to offer the right for all these families now to get an assessment of the support of their needs. And I think that was a big gap that was missing from before. And if you think of all of these years that have gone before us where this legislation could have come into place, and those families have had to manage a lot of the time with very little support, kind of finding their way. And these are children with very, very complicated needs sometimes. So these families really need this additional support. So that has to be welcomed, very welcomed.
That's great, Leslie Ann. Thank you.
Thank you.
Thank you. Okay. I don't see any other indications from members, although I can't see members on screen. I don't see hands raised, but I don't see them if they're physically raised. I wouldn't be able to see those at present. Do members, any members want to indicate just by speaking there if they want to come in to ask Leslie Ann anything before we let her go? No, I don't think so. And if there are questions, Leslie Ann, members would forward them possibly through the clerk if there are outstanding questions that members have that we haven't been able to get just as a result of the system here. But I would like to thank you very much for attending this morning and for that very useful briefing. In what is, all help is greatly appreciated in terms of working our way through what's a very large and a very complex and a very important bill. So thank you, Leslie Ann, and take care.
Thank you. Thank you.
Okay, members, thank you. And I want to check, do we have the next officials?
We're running a wee bit early, so
okay.
We might be as well taking the SRs and coming back to the departmental briefing.
Okay, yeah.
So it's on the agenda item 8.
Okay, so Carol, I just happened to catch a message from you. Your microphone was muted. I may have missed you there because I couldn't neither see you nor see a hand. But if there are questions...
I just wanted to thank Leslie Ann for the paper. I thought it was really, really good. So,
okay, yeah, that's on the record. Thank you, Carol. Okay, members, we will move on then while we're getting officials on the line for the next briefing on that Adoption and Children Bill. We'll move to some of the SRs that are in front of us this morning. So SR, first of all, item 8, SR 2021/198, the Establishment and Agencies Fitness of Workers Revocation Regulations NI 2021. This SR revokes SR 2020/60, which allowed for reduced pre-employment disclosure checks for health and social care staff to help ease the initial COVID-19 staff pressures. I refer members to the papers at tab 8 of the pack, and in particular to the clerk's memo there at tab 8.1. So I'd like to remind members that the committee did consider this SR at the SL1 policy proposal stage at our meeting on the 1st of July, and we agreed that we were content for the SR to be made. However, we sought clarification from the Department regarding full pre-employment checks for those recruited under the temporary arrangements. So in other words, we were checking had those been done in retrospect. The Department's response is included at tab 8.2, in which they confirm that full disclosure checks have now been carried out. The SR is subject to the negative resolution procedure, and the Examiner of Statutory Rules has no issues to raise. So have members any further issues they want to raise in relation to this SR? No, thank you. Members are content. Can I ask members then to agree formally that the Committee for Health has considered SR 2021/198, the Establishment and Agencies Fitness of Workers Revocation Regulations 2021, and has no objection to the rule? Are we agreed? Agreed. Thank you, members. So, members, the next 3 agenda items then are all statutory rules relating to the misuse of drugs. I refer members to the papers at tab 9 to 11 of your pack, and in particular to the clerk's memo, which is at tab 9.1 of your pack. The committee considered the SL1 policy proposals for these 3 SRs at our meeting on the 8th of July, and we agreed that we were content with the regulations. The committee has also asked the Department for further information on drug-related deaths, and the Department's response is at tab 9.2 of the pack. So we will now formally consider each of those SRs, which are all subject to negative resolution. And I think it was welcome that the Department's responders indicate that they will look at providing more information on that, and I think that's important. I think Arlea had raised that previously around the idea of psychological autopsies, that information and data would be useful. So we'll now move to the formal consideration, and they are negative resolution. So item 9 is SR 2021/221, the Misuse of Drugs Amendment Regulations 2021. Have members any further issues to raise in relation to that SR? No, thank you, members. If not, then can I ask members to agree formally that the Committee for Health has considered SR 2021/221, the Misuse of Drugs Amendment Regulations NI 2021, and has no objection to the rule? Are we agreed? Great, thank you, members. Item 10 is SR 2021/222, the Misuse of Drugs Designation Amendment Regulations 2021. The Department has advised that there is a mistake in the title of this SR and that it has been revoked by SR 2021/231, which is the next agenda item. So are members therefore content to note? Yep, thank you. So moving on then to that corrected SR, which is item 11, and SR 2021/231, the Misuse of Drugs Designation Amendment Order NI 2021. I refer members to the papers at tab 11 of the pack, and in particular to the correspondence from the Department at tab 11.1, advising the committee of the error that this SR corrects. The Examiner of Statutory Rules has reported that this SR was laid in breach of the 21-day rule, but that she is content with the Department's reason for this breach. Have members any further issues they wish to raise in relation to this SR? No, members content. Can I therefore ask members to agree formally that the Committee for Health has considered SR 2021/231, the Misuse of Drugs Designation Amendment 2021, and has no objection to the rule? Are we agreed? Great, thank you, members. Okay. Yeah. So we can move then on, members, to correspondence, and we'll keep an eye on the when we get officials, but we can move to correspondence. So correspondence there is contained at tab 12 of your pack, members. And I'd like to draw your attention to a number of items, and then I'll come to members and see if there's any other items that you wish to draw attention to. So item 12.5 is a departmental response to the committee's request for information on vaccine travel passports for travel. Do members have any comments in relation to that?
No, Chair. Sorry, Chair. Can I go back when you have finished this item, because I want to raise an issue under 12.3, please.
Okay, so I'll come back to you. Yeah, I'll work through the ones I have, and then I'll come back to that, Carol. Okay. Moving on to item 12.8 then is from Cara Hunter, seeking member support for the NUS-USA campaign Student Health Heroes, calling for financial support for students on health and social care courses. I know I have noted this campaign. I actually have signed and wrote to them a number of weeks ago, and certainly I do support that campaign, I have to say, and have indicated that support to the campaign as well, very clearly. But I have an indication then from Pam. I'm not sure if it's in relation to this item, Pam. I'll just check with you.
Chair, it was actually in relation to 12.5. I just wasn't quick enough there.
Sorry, well, go ahead. Yeah.
So that was regarding the vaccine travel passports, and it was really to see if we could ask the department if, because it would be useful to know what extent the current demand for COVID certification will be affected by this week's statement around the international travel restrictions being eased for those entering the UK from the 4th of October. So it was just to ascertain, what impact that might have on the subject.
Yeah, members content that we seek that clarification. And also, I think it would be useful if we could see an assessment of what any changes in that, in terms of their assessment of what the impact would be on transmission. I think would be useful to keep an eye on as well, if members are content. Yeah. Okay, thank you. So I'm reverting then back to that item 12.8 from Cara. So I see a hand from Carol. I just want to check, Carol, is that in relation to 12.3, or do you want in on either of those two?
12.3, Chair, and then I also want to raise an issue on 12.10.
Okay, so so are members content then with that request from Cara that members support the campaign? Members maybe, I'm not sure if individually done it, but are members content? Yeah.
Yeah, Chair, I think individually parties have done it.
Okay. Yep. Okay, so item 12.14 is from Birth Mothers for Justice, and in relation to the statutory inquiry which has taken place into mother and babies' homes and the Magdalene laundries. And would members be content that the clerk work with the Assembly's engagement team to look at various options for meeting with a number of groups and individuals? We've made it clear that we will want to continue to keep in touch with those victims, survivors, and families, and to keep an eye on how the process is working. So I think that would be a useful thing to engage with them again now in that respect. Jerry?
Yeah, thanks, Chair. I support that. I think there's a cohort of different groups of people who have been, failed by the health and the care system generally, and these are one such group. So I think it's important for us to meet them, and they've got a lot of obviously issues to air and raise members' awareness of. So I'd support us, taking measures to meet them and listen to them. I think it's vital.
Okay, thank you. So members are agreed that we will progress that important work as well. We remain conscious of the pressures, but I think this is one area that is deserving of particular attention. So that's I thank members for that. So I'll go back then, Carol, to you on 12.3 first of all.
Thank you, Chair. It's really in relation to the indemnity. So the suggestion that from the Department of Health, one of the queries I want to ask is if the indemnity covers care homes and GP practices for public liability and indeed employers' liability. Because we've heard recently, you may recall I raised this around the community and voluntary sector around digital and other forms of indemnity. So, I suppose I want those clarified, and what is the scope after March 2022, please?
Okay, thank you. My understanding is that this was designed to cover locations that hadn't generally been covered within the indemnity as a result of the pandemic, so additional places that operate, health work was taking place on sites that hadn't traditionally or previously been used in that respect, but no harm in taking the clarification. If members
and sure, the reason I'm asking is because it's often women, low-paid workers who undertake this work, and I don't want them to be any more vulnerable than what they already are, to be fair. So if we could get, I'm sure the committee's the same, but if we could get that clarified, I'd really appreciate it. And then, Chair, I want to come back to 12.10.
Yep, go ahead. So committee are indicating that they're content with that, to seek that clarification on 12.3, and go ahead on 12.10, Carol.
So it's really just in terms of, should be forward to the PCC for comment. If we could, supply a full copy of the report, and if a finding to drop the term shielding, what's the situation regarding that?
Sorry, Carol, I just could you say that again? I didn't fully understand that.
Sorry, so in relation to 12.10, the clinically extremely vulnerable engagement platform.
Yeah.
Okay, so it's really to talk about the Patient Client Council for their comments as well. And if we could get a full copy of the report that was referred to, and if the report made the finding indeed to drop the term shielding.
Okay, yeah. So that's to forward to Department for comment as in the memo, but also to forward to PCC for comment and to ask for the full report and around that shielding. Are members content with that? Yep, members content with those items. Any other items, members, or any further comments on any other items of correspondence?
Sure.
I will go to table papers next. Yes, Carol?
Sure. Could I just make a wee comment, please?
Yeah, go ahead.
It's in relation, I know it's for us just to note at this stage, but it was the Department for Justice letter. I'm trying to look here to see what it was. Sorry, members, it was in relation to the protests.
12.13. 12.13, Carol.
Sorry, yes, 12.13. I mean, certainly noting that letter, but it's just to put on the record. Some of these protests haven't just happened at places where abortion as part of healthcare might be offered. They've also happened at health centres where people are looking in to get baby milk, to get babies weighed and other things. So it's just to have that read into the record, Chair. Okay,
thank you. And we will be receiving, I think, in due course, a bill in relation to this as well, a private members bill. So we'll obviously be looking at that in more detail. Okay, thank you, members. So are members then content with the proposed actions in the correspondence memo as amended by the discussion at tab 12.1 of the pack?
Chair. Yeah. Sorry, I know we're jumping back and forward all over the place. It's hard to keep up here. but it was just on 12.14, but the Birth Mothers for Justice issue, and it was just to ask if we could ask the department if there is, and we'll ask them for an update on the issue on follow-up to recent academic work. So if they have any update, could we just get that from the department on that particular issue?
Yeah, members content with that proposal? Yeah. Thank you.
Thank you.
Thank you. So are members content then with the proposed actions in the correspondence memo and as agreed in the discussion? Yeah, thank you. Thank you, members. Moving on to tabled papers then. Do members have any comments in relation to any items in tabled papers? No, members are content. Okay, so I'm going to check back with the clerk now. Do we have departmental officials? Yes, we appear to do. So I'll go back then to our departmental briefing on the Adoption and Children Bill. So department officials are here today to brief the committee on the principles of the bill ahead of second stage. I refer members to the bill and the EFM at tab 7.1 to 7.2 of your pack, and to the speaking notes provided by the officials at tab 7.3 of tabled papers. Given the size of the bill, the officials will brief today on part 1 of the bill, and then will brief us on part 2 of the bill next week. So if members can bear that in mind when it comes to questions that we're dealing with part 1 today and part 2 next week. So I'd now like to welcome back to the committee Ellis Mcdaniel, who's Director of Childcare and Family Policy. Good morning, Ellis. Can you hear me okay?
I can indeed, Chair. Good morning.
Good morning, thank you. Julie Stevenson, who is Head of Adoption and Children Bill Team. Can you hear us okay, Julie?
Yes, I can. Good morning.
Thank you. And Frances Nicholson, who is Social Services Officer. Can you hear us okay, Frances?
I can indeed. Yes, good morning.
Thank you. So just in terms of working our way through the session, if I could ask if people have access to headphones, that's usually helpful. If I could ask both panel and members to remain on mute when you're not speaking. And again, given the complexity of the bill, if I could ask maybe one member of the panel to lead on an answer, and then if there is additional information that is required, but if we could sort of keep it focused in that respect. So I just ask members to be as succinct as they can be in panel with answers, bearing in mind that this is a huge bill and one that I guess there will be a lot of questions arising from. So I'll go back to yourself, Eilish, then. Just do you want to outline how you want to deal with the briefing, and then we'll go to members' questions?
Okay, Chair, thank you. My plan is to take members through the key provisions in the bill as they relate to adoption, if you're content with that.
Yep, absolutely. Eilish, go ahead, please, Lana.
Okay, so as you pointed out, I'm sure this is the first of two briefings on the bill, which was in the Assembly on the 20th of September. It represents the first overhaul of adoption legislation in almost 35 years. The Children Northern Ireland Order of 1995 will also be amended by the bill. It's the key body of legislation for children's social care, and it's now more than 25 years old. This bill has been a long time in development, and this was due to a number of factors, the majority of which I think the committee is aware of. In developing the bill, we considered legislative developments relating to adoption of children in other jurisdictions of the UK. And
sorry, Eilish, apologies for interrupting you. The microphones seem very, very sensitive today, and any movement of papers is cutting across and actually drowning you out. So it has actually been the case with my own sound here earlier as well, I believe. So just be really careful about that. The microphones are picking up every noise there in terms of paper, so just be aware and alert to that, Eilish, please. Go ahead again.
Okay. I've moved slightly away from the microphone, and I hope that helps. So I started by saying that we considered legislative developments relating to adoption and children in other jurisdictions of the UK, and many of the measures are similar to those in place in England and Wales since 2005 and in Scotland since 2007. The bill, or the policy underpinning it, has been subjected to public consultations, firstly in 2006 and then in 2017. And there's been extensive stakeholder engagement. Consultees indicated overwhelming support for the bill in the 2017 consultation. You've acknowledged, Chair, that the bill is substantial. It has 160 clauses and 5 schedules. It will strengthen the current legislative framework around adoption and care. And today I'll provide members with an overview of the key provisions relating to adoption. The bill puts the welfare of the child front and centre of adoption decision making by courts and adoption agencies. It introduces a welfare checklist, a list of things that must be considered when deciding whether adoption is in the best interests of the child. Among other things, the list prompts decision makers to consider the value of a stable and harmonious family to a child, what the child wants and feels, and his or her particular needs. Importantly, welfare in connection with adoption means lifelong welfare, and because adoption is a lifelong commitment. To tackle any unnecessary drift and delay within the adoption process, the bill will introduce a statutory principle of no delay in adoption decision making, and courts will be required to draw up timetables for resolving cases without delay. The current Adoption Regional Information System, which we refer to as ARIS, which is used to match approved adopters with children waiting to be adopted within and across trusts, will be placed on a statutory footing. Regulations will set out the framework within which it will operate, including the supply, retention and disclosure of information. The bill will place a duty on each trust to provide a fit-for-purpose adoption service, one which meets the needs of everyone connected with adoption in terms of assessment, placement and support services. It will be possible for trusts to engage voluntary adoption agencies registered with the RQIA in the provision of adoption services, drawing on their extensive expertise. An unregistered voluntary organisation may also provide certain adoption services on behalf of a trust, and we would specify these in regulations. The bill will also enable some adoption functions and services to be undertaken or delivered on a regional basis by, for example, one trust on behalf of the region. And this could promote greater efficiency, more equal access to services, and consistency of service user experience. Under the bill, adoption support, which must be provided, will include financial support and access to counselling, advice and information relating to adoption. Other support services that must be provided will be specified in regulations. Any person will be able to request an assessment of needs for adoption support at any time, before or after an adoption order has been made. Trusts will be under a duty to undertake such an assessment if requested by a child who is to be adopted, prospective adopters, birth parents, adopted adults, their parents and natural parents. In all other cases, the trust will have the discretion to decide whether to undertake an assessment. And following an assessment, if the trust decides that support services should be provided, it will be required to prepare a plan and keep that plan under review. Also, trusts will have the duty to provide information about the types of adoption support services available in their areas, so that those interested in adopting and adopters are better informed about adoption support services, their rights and other services. There are two routes to a child being placed for adoption. The adoption agency can secure a placement order from the court, or a birth parent can give consent to placement for adoption. Placement orders are new. They will replace freeing orders. Freeing orders have been widely criticised, partly because once made, parental responsibility for the child transfers completely from the child's parent to the adoption agency. Placement orders will authorise a trust to place a child with any adopters it selects. The parents may apply to revoke the order, but only if the child has not been placed with prospective adopters and only with the leave of the court. Leave will be given only if the parent's circumstances have changed since the order was made. Unlike freeing orders, when a placement order is made, The birth parents keep parental responsibility for their child, although it is shared with the adoption agency, until the final adoption order is made. And once the child is placed for adoption, the prospective adopters will also share parental responsibility for the child. A birth parent can also give consent to their child being placed for adoption, and where this happens, the adoption agency will not need to apply to the court for a placement order. Under the bill, parental consent will replace parental agreement. Parents may consent to a placement with named or unknown adopters. The bill also enables birth parents to give advance consent to the final adoption order when consenting to placement or any time afterwards. Even though parents may give consent for their child to be placed for adoption, they can, at any time up until the point that an application for an adoption order has been made, request the return of their child. And if an adoption agency remains of the view that adoption continues to be in the child's best interests, it will have to apply to the court for a placement order. However, once an application for an adoption order has been made, and regardless of whether proceedings have or haven't commenced, the court's consent is required for the return of the child. Where a parent has consented to placement for adoption, he or she may oppose the final adoption order in the course of proceedings, but only with the leave of the court. And the court may give leave only if there has been a change in circumstances since the parent or parents gave their consent. The new system is intended to be fair to birth parents, allowing them to share parental responsibility until the making of the adoption order and to withdraw consent up until the point at which an adoption order is applied for. It will also minimise the risk of a contested court hearing at the adoption order stage and provide greater certainty for children and prospective adopters by dealing as far as possible with parental consent before the child has been placed with them. As under current arrangements, a court may dispense with parental consent when making a placement order or an adoption order. However, only two grounds for dispensing with consent will apply. They are where the court is satisfied that the parent or guardian cannot be found or is incapable of giving consent, or that the welfare of the child requires the consent to be dispensed with. The bill also sets out the process for applying for an adoption order, other than through an adoption agency, and that we refer to as a non-agency adoption, and the conditions for making adoption orders, who's eligible to apply, and the effect of adoption orders. In non-agency adoption applications, the child must have lived with the person for 3 years before an application for adoption may be made, and where the person applying is a step-parent or an authority foster parent, a 1-year requirement applies. The current law on who can apply to adopt has been carried through in the bill. Applications can be made by both single people and couples, and that includes married couples, civil partners, or two people living as partners in an enduring family relationship. Applications can be made by men or women, including those in same-sex relationships. And that was addressed by the courts a number of years ago as a result of a judicial review. Eligibility to apply to adopt and suitability to adopt are very different things. Prospective adopters are currently and will continue to be subject to a rigorous assessment process to ensure that only persons capable of providing a loving, safe and secure home are approved to adopt. The welfare of the child will always be the overriding consideration. Under the bill, it will be possible for someone whose application to adopt has been turned down to seek an independent review. The review mechanism will also support our efforts to build confidence in the adoption approval process and potentially encourage more people to come forward to adopt. When making a placement order or a final adoption order, the court will be required to consider any contact arrangements which the agency has made or proposes to make. And the policy intention is that there should be no presumption either for or against contact, and the welfare of the child will continue to be the paramount consideration of the court. The court will be able to make an order for contact before or during a child's placement for adoption, and a children's court guardian will be appointed to represent the child's interests in such proceedings. When making an adoption order or afterwards, the court will be able to make a further contact order requiring an adoptive parent to allow the child to have contact to visit or to stay with their birth family, or prohibiting contact, and that will depend on the best interests of the child. The bill also provides for the disclosure of information and access to adoption case records. Adoption adults will continue to be able to obtain a copy of their original birth certificate from the General Register's Office. People adopted before the bill is enacted, referred to as pre-commencement adoption, will continue to request this directly from the DRO. People adopted after the bill is commenced, referred to as post-commencement adoptions, will access this information through the adoption agency and not the GRO. Any adopted person seeking access to their birth record will be advised that a counselling service is available. Those adopted before the 18th of December 1987, which is the date when the current adoption legislation came into operation, will have to attend a counselling interview available through an adoption agency before the Registrar General can provide access to their original birth record. If they're living elsewhere in the UK, other bodies may provide counselling services. So, for example, a local authority or an adoption support agency in those jurisdictions. The existing adoption contact register maintained by the Registrar General will be enhanced so that adopted adults can indicate who they want to and don't want to have contact with. Also, birth relatives will be able to indicate whether they want to have contact with the adopted person. And not every adopted adult or birth parent will want contact, and we have to respect that. Adoption case records held by adoption agencies also contain relevant information that an adopted adult and others may wish to access. For pre-commencement adoptions, there will be no change to how people can access such records. The current framework under the adoption agencies regulations of 1989 will continue to apply, so that adoption agencies retain the discretion to disclose as much information from the records as is reasonably possible, subject to other legislative requirements and considerations. So, for example, data protection legislation. As a result of the ongoing work in relation to historical mother and baby institutions, work is underway to develop guidance for adoption agencies on the disclosure of adoption records held by them. The work is being taken forward on a co-design basis. Survivors of the institutions are working alongside social workers to produce the guidance. And the guidance will make it clear that as far as possible, each agency should operate from the premise that all information relevant to his or her birth and adoption should be disclosed to an adopted adult, subject to the impact on other parties being fully considered and the necessary supports being put in place for each adopted adult seeking disclosure. For post-commencement adoptions, the bill will also enable any person to access adoption case records held by an adoption agency, and will set out how this should happen, including a power to specify arrangements and requirements in more detail by way of regulations. Where the information requested includes protected information, and that is identifying information about another individual, the adoption agency will have to take a number of factors into account when deciding whether to provide the information. It is intended that the independent review mechanism that I've referenced earlier will also extend to decisions about disclosure of protected adoption information relating to an adult. Individuals will be able to ask for an independent review if they're not content with the decision made about disclosure of such information, including a decision not to disclose. Intermediary services and counselling services will also be made available to support adopted adults and birth relatives wanting to access information or to make contact and to anyone related to an adopted person by blood, marriage or civil partnership, or adoptive relatives who wish to make contact with the adopted person's birth family, and that's new within the legislation. The bill will also strengthen safeguards for children being brought into or out of Northern Ireland through an inter-country adoption. All prospective adopters in Northern Ireland will be subject to the same rigorous preparation, training and assessment, regardless of whether the child they're seeking to adopt lives in the UK or overseas. The bill also introduces a new part for the Department to charge a fee for the administration of inter-country adoption casework, which the Department undertakes. The Department will also be able to establish a specific Northern Ireland designated list of countries outside the UK which have sufficiently robust adoption procedures and safeguards in place to merit adoptions in that country being legally recognised in Northern Ireland. We'll also be able to place countries on a restricted list in circumstances where their adoption legislation, their practice or procedures are insufficient to ensure the proper protection of children and their families. It's anticipated that all jurisdictions of the UK will remain closely aligned in their decision-making relating to either designated or restricted lists. And that concludes my overview, Chair, of the adoption provisions in the bill. We're happy to take any questions members may have. I'm very conscious that there are a considerable number of provisions in the bill, and very content to provide any material to the committee that will actually assist you in your scrutiny of the bill. One thing has also been suggested that we invite adoption social workers to brief the committee formally or otherwise, and certainly very happy to organise that, Chair, if that is still required.
Okay, thank you, Eilish. Thank you for that useful briefing, and I suppose there are a massive issues here. I will just quickly declare my interest again as having worked previously as a social worker and worked with looked after children, adoptive parents, foster parents, and agencies involved in all of these considerations. You'd mentioned that this is based largely or follows to some degree legislation that's been put in place in England and Wales since 2005 and Scotland since 2007. What learning has there been, or reviews have there been, or what elements of what issues were highlighted as potential difficulties that we have the ability to learn or to improve our proposed legislation?
I mean, there are some measures that I can refer to very specifically, and I'll ask Julie to come in behind me here, particularly in relation to adoption provision. But so, for example, and this strays into the next session, special guardianship orders have been in place in England since 2005. They haven't run entirely smoothly there, and we've taken the learning from England and addressed some of the what I would describe as deficits present within SDO arrangements within England. So, for example, we will impose a residence requirement in relation to SGOs in Northern Ireland, and we will also require applications for special guardianship orders that relate to looked after children in Northern Ireland to be put before a panel for consideration and a view. Julie, do you want to say anything in particular about adoption provision?
Yes, actually most of the adoption provision, we have maintained quite a consistent approach with England and Wales, and that is very much on the basis that obviously adoptions work within across the jurisdictions. More so the aspects in adoption that we haven't probably taken forward here relate more to the scale of Northern Ireland compared to England and how England operates across so many local authorities. So it's more around where England have done a lot of work around regionalisation of adoption agencies and introducing adoption support agencies and adoption support advisors. We considered that for Northern Ireland purposes that we did not need to take forward that same provision for Northern Ireland, given that we are working on a much smaller scale across the 5 health and social care trusts.
Chair, there are other examples relating to support services. For example, so the department has also taken powers to require certain support services to be provided. That's new in Northern Ireland legislation. That doesn't exist in England and Wales. And what we're trying to do there is to make certain that people are getting access to the support that they actually require to meet identified or assessed needs. So I think there are quite a few examples, and we've given you some of them. If you'd like a bit more detail on that, we can provide it to the committee.
Okay, thank you.
I think most of where we did take learning and differ slightly, we've adjusted things, will be more apparent in the children order provisions of the bill when we come to discuss those next week. Okay,
thank you. You also refer to the no delay principle, and I have to say, and I fully agree with the overarching theme here, that the child's interest must be put at the very centre of this, but you also have then the other interests of birth parents, birth families, adoptive parents, foster parents, and all of that. But the no delay principle, the converse of that no delay principle, could be seen as undue haste, and there has, I suppose, been issues in the past where people have families who are involved in these proceedings have felt they're kind of up against quite a large monolith, and that family proceedings can be very opaque. So what guarantees are built into this that parents will be supported with information, and that they will be able to engage in all of this on the basis of equality of arms, to use that term, that they will be supported to engage against agencies that may have much greater resources than them?
Again, I suppose what you're pointing to differences within Northern Ireland that currently exist. So it does take much longer in Northern Ireland for a child to be adopted, to be taken right the way through the process from their last entry into care, for example, until an adoption order is made. And the time difference, or the duration difference, between ourselves and England is quite considerable, and I think you're quite right, Chair. It's important that we give very careful consideration to the adoption of a child, both within the adoption agency and within the court itself. Julie, Francis, do you want to add anything in terms of the safeguards that are in place?
I suppose basically we have safeguards within the agency, all the adoption agencies through their panel. So the actual decision, has to go through a panel recommendation that adoption's in the child's best interest, and that will take into account the birth parents. Are there any alternative families within the family? Are there any alternative placements? So we have those already within the agencies, but we also will have them within the court process, and they're re-examined again within the court process. We would also always encourage birth parents to seek, and we would provide through Next Step independent counselling for birth parents, and support and advocacy really for them as the process is going through. So we really feel that will protect their interests as they go through this process, which is, as you quite rightly point out, it is really quite bureaucratic and quite difficult for birth parents. So we are alert to that and providing as much support as we can through the bill in both agency terms and in both court terms. They obviously will also be legally represented in court.
Thank you. And I actually had noted down a question to ask around support for birth parents, and I was pleased to see that you did come on in your briefing, Ellis, to indicate that would be the case. But will that support reach back to support parents to be, and there's a concept within social work, good enough parenting? Not everybody's parenting is maybe what other people would judge to be the way they would parent. So taking into account the close bond and that very important birth bond, will there be sufficient support put in to allow birth parents, or to support birth parents to be parents in a way that does put the child's interest at heart, rather than moving to a presumption of adoption and then supporting the families through the adoption process?
Okay, so there's two things I suppose I would say in response to that. So one of the things that we're very conscious of now is providing as much support to parents as we possibly can to enable them to look after their own children. And if you look at the Delivering Together strategy, that's one of the commitments that is actually made within it. I suppose also you've got to, some of the things that we've done in recent years is to introduce what we've called concurrent care. And through concurrent care, there is the possibility or the potential for a child to be placed with a prospective adopter, to be actually returned to their parent through that process. That's a fairly recent development. We established a pilot scheme around 2014, which ran through to 2018, and it's now being mainstreamed. But it does create the potential through working with parents as part of that concurrent care process for some children to return to their parents, and some of them do. They're small in number, so it's a small percentage, but through concurrent care, some children actually do remain with their birth parents and are not adopted.
Okay, thank you. A couple more quick ones then. You had said that parents can appeal only if the child has not been placed with the adoptive parents, with the adopters. And then you went on to say that before adoption, the child must be with the adoptive parents for 3 years. So at what point does that right to appeal disappear? Is it when the child is first placed pre-adoption, or only after the adoption has been put in place?
Francis, could I ask you to take that from the chair, please?
Basically, the need for the child to be resident with the adopters is a non-agency placement. That 3-year requirement is when applicants, so an adoption agency is not involved in the placement. The 3-year requirement comes into being now. Adoption agencies or the trusts are required to provide a report to the court around the circumstances and whether adoption is still in the child's best interests. That 3-year requirement is not for placement adoptions, and we would be working openly with birth parents, and it is hoped through this bill that working relationship will be much more upfront and supportive throughout the whole process, which is why I've referred already to independent counselling and support being available, and the hope that birth parents will take this up. So I suppose the move to them being able to withdraw their consent really will only be if there's been a change to their circumstances after the placement with the prospective adoptive parents. So there has to be an indication that there has been a change to their circumstances once the actual adoption application, in other words, once the actual adoptive parents apply to the court for the adoption order. Okay. I hope that's clear, Chair.
Yeah, that does partly clarify that, and thank you for that. The last one from me then, before we go to members, is you have mentioned within your briefing that the legislation will provide the right to apply, or the ability to apply an inter-country adoption fee. Now, regrettably, Eilish, in your presentation, I don't think we've heard a single thing about what the situation is as regards adoption in the 26 counties. And my concern from that arises from the issue, particularly but not solely, on kinship care, where we have families living on either side of the border, and there may be a very good option in the child's interests in that respect. So can you tell me how this legislation would interact and more importantly cooperate with the situation in the 26 counties? And could you also provide the committee with a written briefing in relation to the situation in the 26 counties? Because with all of these types of legislation, the committee does, I think, need to understand how that interacts across the island of Ireland, particularly in border communities where people are living and married and living on both sides of the border. So can you give me an indication on that, please?
Certainly very happy to provide you with a written briefing on it. I'm going to rely on Francis here to come in behind me, but an adoption that takes place between Northern Ireland and Southern Ireland will be classified as an inter-country adoption, and all of the rules under inter-country adoption will apply. Now, one thing that I would say is that where the adoption relates to, for example, a child who is in care and who is going to be placed with family for the purposes of adoption, I can't foresee the department applying charges in that case at all. It's a part of charge. We will also have the discretion not to charge, Chair, but I can't foresee any circumstances in which we would actually apply a charge to an adoption involving a child moving from Northern Ireland to Southern Ireland for the purpose of adoption, a child who's in care, I mean. Francis, do you want to add anything to that?
I think just that obviously both jurisdictions have ratified the Hague Convention, and that provides like an umbrella process and I suppose reassurances for both countries that their adoption processes are Hague compliant. So it probably makes us more content to work with other Hague countries, because we already know that everybody has signed up to the Hague Convention. So hopefully it will be easier, but it is still an inter-country adoption process. We accept that.
Well, I'm not. I will be looking into this in more detail. I'm not sure that's an appropriate way to go forward. I don't think a family living in my own constituency with maybe a person living in Autism and her sister lives in Vale, if she would recognise that she would be able to adopt her nephew as a result of the Hague Convention rather than the normal everyday conventions that exist in our community. And I think that actually should have been considered. I'm not sure that inter-country regime is appropriate here. I don't fully, I will admit, understand how much more difficult or how much more inaccessible inter-country is, but I think that will have a bearing, because whatever we do here has to recognise the reality of people's lives on this island, and this in particular is not only a hugely difficult area, but also there are huge opportunities in terms of, and I think we all recognise, first and foremost, a child ideally should be with its own birth parents. If that's not possible for whatever reason in the child's interest, then family are the next go-to, and we will have many people who will be in that position across the island, but particularly in border communities. So I think that probably should have received more consideration, and it will be an issue that I will want to return to, because I think if we are genuinely operating in the child's interests, then we need to operate on the basis of reality, not on the basis of lofty conventions, but on the basis that children live, go to school, stay with their aunt and uncle on the other side of the border, play football on the other side of the border, etc. So I'll come back to that. But anyway, I am then going to go to members' questions. So I have Pam Cameron first of all, then I have Jerry, and then Carol. Go ahead, Pamela de Hull.
Thanks, Chair, and thank you, Ellis, Julie and Francis, for your time today. This is obviously a huge bill, and it's a very important bill. So, and apologies, I probably have too many questions, and if it's okay, through the clerk, I would like to maybe be able to submit some to you in writing for written response. It might be easier going forward, just to keep track of where we are with it all. But just kind of to kick off, and we've already touched upon, how long adoption takes currently, and so what I wanted to ask around the existing processing times. What are they in Northern Ireland, and how do they compare? I know they don't compare favourably, but how do they compare with other UK regions? That's my first question.
Okay, so the average time taken for a child to be adopted, and that's from their last entry into care. And what you need to understand, Pam, is the majority of children are now adopted from care. So out of 127 children that were adopted in 1920, 111 of those were children who were in the care system. So the duration is measured then from their last entry into care through to an adoption order being made. That is 3 years and 2 months in Northern Ireland. I think it's 37 months in England. It's 23 months is my understanding, and in Wales it is 26 months. So a considerable difference in terms of duration, certainly between ourselves and England, but the chair has already pointed to the need for the adoption of a child to be given very careful consideration through the process of adoption. We did set a target a number of years ago of 3 years for adoption to be completed within Northern Ireland, and the average duration is I think I said 3 years and 2 months. It is actually 3 years and 1 month. So the average duration is in line with the target that we set. That said, there will be different timeframes for different children. Some children are harder to place for adoption than others. For example, so children from a sibling group will be harder to adopt than an individual child. Unfortunately, children with disabilities or medical conditions or developmental delay, it's a fact that it is more difficult for those children to be adopted, and that unfortunately is reflected in the timescales for adoption.
Okay, Ellis, for clarity there, so in Northern Ireland currently it's 2 years and 1 month.
Sorry, I'm completely confusing you. 3 years and 1 month, 37 months. And in England it is 23 months, and in Wales it is 26 months. I'm using months to make it easier for me to remember, if I'm honest with you.
Okay. And in terms of adopted babies less than 6 weeks old, is that the same? Are the same timescales in place for very young children of under 6?
The reference to 6 weeks relates to consent, Pam. So it is not possible for a parent to give their consent until 6 weeks has actually expired. Doesn't mean that a child couldn't be placed for adoption within that 6 weeks period, but consent will need to be revisited at 6 weeks. So that is the relevance of 6 weeks within the adoption process.
Okay, so it doesn't change the timescales at all.
No, I mean, the process is the process. The child of whatever age has to be taken through the process. Obviously, a younger child who enters the process will be adopted at a younger age. I mean, that's the natural consequence of that. But the reference to 6 weeks is relevant, has relevance to consent.
Okay, that's great. Thank you. And could you tell me what clauses the officials you would identify as the main thrust of the bill in terms of improving the legal framework and promoting more functional documents?
I'll ask Francis and Julie to come in behind me here, but given the discussion that we've just had, for example, around duration, I think the introduction of the no delay principle and the requirement on courts to to establish a timetable for a case to conclude through court. I think that's really important. I think some of the support provision within the bill likewise is critical. It's important that we support people not only through the process of adoption, but also subsequent to adoption. So if you consider that the majority of children now who are adopted from care, some of the challenges that those children had earlier in their lives have left a mark, and that mark is not obliterated by way of adoption. So for me, adoption support, again, is really critical. I think the replacement of freeing orders with placement orders, again, quite significant, principally because it enables a parent to maintain parental responsibility for their child until such times as the adoption order is made. They're the standouts for me. Francis, Julie, do you want to add to that?
I personally think that those are the main ones. You know, the support and the ability for the request for an assessment of need at any stage throughout the process is very key, and that we will be prescribing the types of support for all that should be made available for all categories of people affected by adoption. So that will include, you know, everyone involved in the process, and the placement order replacing freeing orders, and the birth parents retaining their parental responsibility, I think will be key to hopefully, hopefully leading to less contested adoption proceedings.
Yeah, and I think additionally, adding in the welfare checklist, which to a large degree mirrors the welfare checklist from the children order, but adds in the lifelong implications for adoption. I think for agencies and courts to have to go through that welfare checklist will be beneficial in making, you know, the child's needs paramount, really, and looking at why adoption is so important to that child. So hopefully it'll bring clarity in the agency and court processes earlier, and that will in time, eradicate delay.
That's great, thank you for that. I want to ask another question on there's a number of elements in the bill separate to adoption processes dealing with things like the educational underachievement among looked after children and support for care leavers. I'm just wondering, why was the decision made to include them within the adoption bill, and are there not grounds for a standalone children's bill?
I suppose we took the opportunity presented by the plan to amend adoption legislation to make changes to the children order that we considered was necessary. I think it will become evident next week, and Julie's already referred to it, that the provision within the bill as it relates to children and the amendments that are made to the children order are quite substantial. They may have merited a bill in their own right, and I think there were occasions when we considered whether it was appropriate to do that. But if I'm honest, we took the opportunity presented by the need to overhaul adoption legislation, and when we consulted on a range of proposals, then we introduced further changes to the children order that were drawn to our attention through consultation.
Thanks for that, Eilish. And can you tell me, have issues such as educational underachievement, have they been included in other jurisdictions within their legislation, or are we doing something different?
I think we have mirrored some of the provision within the Children Act in England. but certainly the provision as it relates to educational underachievement is to deal with a problem that is currently present in Northern Ireland. Children in care significantly underperform through no fault of their own in relation to education. The gap between them and their non-peers is quite significant, so it would have been remiss of us not to include something within the bill intended to address educational underachievement among the care population. But you're right, it mirrors some of the provision in the Children Act.
So if I could just come in there, sorry.
Go ahead.
If I could just come in there to say that most of the Children Order amendments were identified following a scope and exercise of the legislation that has been brought forward in England and Wales in the intervening years while we've been working on the bill. There's been a number of the steps of primary legislation, and the two educational amendments in relation to promoting educational achievement and not disrupting education when considering a placement for a child, they were both included in the Children Act at a later stage. And also the care leavers provision as well was added in England and Wales. So it was that made us consider whether this is something that we should do and do as soon as possible when the opportunity arose in the bill.
That's very useful. Very useful. Thank you for that, Julie. So basically, this is an advantage to the fact that we are behind the other legislators, and we're learning from where they've been. I presume then that it's not a case, or is it a case of does Northern Ireland have specifically worse problem with that educational underachievement?
It's a problem across the board. Just exactly how we compare with other jurisdictions, I can't tell you off the top of my head, Pam, but it's certainly something that we can look at for you and provide you with that information in writing.
Oh, that's great. Thank you very much.
Okay, thank you, Pam. So going to Jerry.
Thanks, Chair. Thanks for the presentation. Ellis, if I picked you up, you said there was consultations done already on this bill. I think a few years ago. Can you detail how many responses were put in? Breakdown of engagement. As break it down in terms of social workers, people who are looked after, etc. So, if I picked you up correctly, that was on the main aims of the bill. I understand this is now being presented in detail now, but was that the case? And if so, a breakdown, please, on who those different organisations were.
Okay, I'm going to ask you to come behind me here, but certainly there were 71 responses and consultation from a wide range of groups and individuals. That's in addition to some of the stakeholder arrangements, groups, etc., that Julie and her team have actually established as part of the pre-consultation and consultation process. Julie, you're better equipped than I to provide the detail.
Yeah, we certainly, I don't have to hand the exact breakdown of all of the responses, but we, an analysis that way to hand, but we can certainly provide that to you afterwards. But we initially have a stakeholder group established, which consists of representatives across the statutory and voluntary adoption agencies and also children's services. It's quite a large stakeholder group, and they've been working alongside us for a number of years in developing, in helping us to prepare for the consultation, and also then following the consultation to work through some of the issues that arose. And we expect that stakeholder group will continue to support us and help us as we come to the legislation, the subordinate legislation, to implement the bill. In relation to the 2017 consultation, we attended a number of events across all of those sectors. We did an event in each of the trust areas, attended mostly by practitioners, social workers, and then we also, each of our stakeholder organisations also facilitated events with their membership organisations, their members, and we attended those and answered questions. And this included foster carers, adoptive parents. They were really helpful in facilitating that. And then finally, we also worked with VOIPEC and also Bernardo's, who facilitated events with children and young people. And then we had a children and young persons version, and we VOIPEC actually prepared a response on behalf of their young people, reflecting the views that they had gathered. But we can certainly give you an exact breakdown of that.
Thanks.
On this meeting.
That'd be useful, and then also if we can get a breakdown of the stakeholder group as well, and what organisations are on it, that would be useful. Just two quick other questions. I presume there's consensus on the proposals and what's being suggested in the bill, and if there isn't, what areas are sort of controversial or contentious or being queried or quizzed. And then just kind of in sort of layperson's term, just, can you give a sense of how this bill will increase the number of people who are able to adopt? And that's me for now. Thanks.
In response to the question about consensus, so I think it's fair to say that there was overwhelming support for what was contained within the bill that we consulted on back in 2017. There are a number of issues that we have had some opposition to. The first of them is less about opposition and more about the decision of the department subsequent to consultation, and that relates to the establishment of the Children and Young People Strategic Partnership on a statutory basis. We consulted on that proposal. Those who responded were supportive of it, and for a number of reasons, which I think we could provide to committee in a bit more detail, probably in writing. We have not included provision in the bill for the establishment of the partnership. Other issues that are slightly contentious, I suppose, are around the support provision and the requirement to assess, but not a requirement to provide. So that has created some issues for those who have responded to consultation. Julie, do you want to add to that at all?
Yeah, just if we can.
Yeah, we have we've been liaising with our stakeholders, as I say, constantly or continually, and indications are, although they're so supportive of the bill and they really want to see it proceeding, I think in their view, while they're happy with everything that's in the bill, there are probably some areas where they would like us to go a bit further. And that would be around, as Eilish said, the adoption support, the duty to provide services assessed as needed. Where we have a power, they would prefer to see that strengthened. Other aspects were, again, around a children order provision around short breaks for disabled children. We have a power to prescribe other groups that could receive such short breaks without having to be looked after. Indications are that some stakeholders would have liked to have seen that prescribed. Harm, it's been raised to us about the definition of harm. The amendment we're making, they might want that strengthened a wee bit, but it's more around where they just want us to go that bit further, rather than any major issue with what is in the bill already.
Could we get those concerns, if they're written down, could we get a copy of those concerns about the partnership and the support provision from the organisations?
Well, certainly we can provide you with an overview, but it's been just really in conversations with our stakeholders as they prepared, I think, to provide their written evidence to you. And I imagine they've simply discussed those with us. Now, whether they decide that they want to request those or suggest those in their written evidence to you.
And just finally, is it one or two organisations, or is there multiple who have concerns?
I think maybe what might help you is the report on consultation. I think if we provided that to you and maybe drew your attention to some of the issues within that report that indicate that, as Julie has said, individuals might want us to have gone slightly further than we have gone. If that would be helpful, we can do that for you.
Thank you. Thanks.
Okay, thank you. And going then on the video link there to Carol. Carol, Railat, leis an ceist, leis de ceist Liddahall.
Thank you, and thank you, panel. I mean, you have said it yourselves that it's a massive bill, and Pam's asked a lot of questions, and like her, we may want to come back for further questions in writing. I'd appreciate this is only the first part. One of the queries I would have is I would like to see the consultation report, because in relation to, first of all, the issue of harm, what are the definitions and what are the criteria that is used. That's one thing. The second issue for me is around, so at the minute health and social services are under a lot of pressure, and that pressure will continue, particularly given the funding envelope that we have. But in relation to adoption agencies, how many adoption agencies are there currently?
Okay, so there are two kinds of adoption agencies. There are statutory adoption agencies, which are essentially our 5 trusts, Carol, and then there are voluntary adoption agencies, and I understand we've now got 3.
Yeah, that's correct, Ellis.
In Northern Ireland. Francis, do you want to name them for Carol, please?
So, Family Care Adoption Services, Family Roots, and the adoption part of Family Roots, and then Bernardo's have just registered within the last couple of months as an adoption agency in Northern Ireland. So those are the 3 registered with RQIA.
Okay, appreciate that, because one of the concerns I had was we are about to take evidence around mother and baby homes, and I'm assuming that Family Care and Family Roots aren't based in any religious churches or religious orders, that they're totally civil.
They are now. They are, but they historically would have had some roots in church organisations.
Yeah, but they're not. They are now, Francis. No, that's helpful. And then I was aware of the 5 trusts all have their child or their adoption and fostering services. So I suppose the issue I would have is then just the definition of harm, and then what criteria any panel would use. So I'm assuming the panels are all statutory based rather than voluntary based.
Francis, do you want to ask a question about panels first of all, and then I'll come back to harm?
Okay, so we're referring here to the adoption panel, and currently, really the makeup of the adoption panel is prescribed in the current adoption agency regulations, so it should be no bigger than 10, but there are independent people. The expectation is that there are some independent people from the adoption community, so be they either adoptive parents or an adopted adult, or on occasion, and very rarely, a birth family member. So there is encouragement for representation on the panels currently. Obviously, with the bill going through, there will be a new set of regulations, and we will obviously consult on how the panel will be made up and add additional criteria to it. Currently, there will always be an independent or a chair of the panel that has experience of adoption work, and that's prescribed extensive experience of adoption work. But there will also be a member of the adoption agency's management committee. So if that's a trust, it will be a trust board member must sit on the panel, or if it's a voluntary agency, it must be a member of their management committee. And then you'll always have to have legal advice available, and you also will have medical advice, because obviously there's a great interface between medical issues for children and young people being placed for adoption, and also in respect of adoptive parents. So, and that I expect will continue into the next set of regulations as well, because these aspects of adoption will continue, like genetic history is very important, etc. And also that prospective adoptive parents really know as much as possible, and this is part of the issue, possibly about delay. You need good updated medical assessments when you're approaching prospective adoptive parents about particular children, so that you can tell them as much as possible. And we all know that when children are younger, it's quite difficult to anticipate how they will actually develop, and if they have any developmental delay, will that continue, or will it in the long run even out? So we do expect those added disciplines to continue to be part of the adoption panels.
Thank you, Frances. Ellis, you were going to come in and talk about the harm.
The definition of harm. We've amended the definition of harm, or the bill has provision within it to amend the definition of harm within the Children Order. Now, that is for the purpose of bringing domestic violence, I suppose, into the definition of harm. So it relates to a child actually being witness to experiencing domestic violence, domestic abuse. It constitutes harm under the Children Order. And I suppose, while it's a reflection of what our child protection services are dealing with quite frequently now, and domestic violence and domestic abuse is actually a very prominent feature within families in Northern Ireland, unfortunately, and we want to ensure that a child actually being witness to that is viewed as, is defined as harm, and potentially child protection responses or looked after responses are I suppose developed or triggered by that, or respond to that as a form of harm. I hope I've made sense. But we have amended the definition of harm to capture domestic violence and children being experienced to it or witness to it.
Okay, and just the final question is, in the current legislation, the criteria that a panel will use around agreeing to an adoption, is that available, and what, if it's going to be amended, would it be amended to?
Frances, do you want to come in on that one?
Right. So currently the panel have, their functions are set out in the adoption agency regulations. So the first thing, or one of the things that they do, is obviously recommend that applicants are suitable adopters. Eilish has covered that in the original functions really of the bill about suitability and eligibility. So they really, I suppose, go through the agency's assessment on prospective adopter suitability in great depth, and then they will recommend if they are suitable adopters. Then each child that is going to be considered for adoption, be that with agreement or non-agreement, their circumstances are brought before the adoption panel, and the panel recommends whether adoption is in that child's best interest, and currently recommends whether or not an application should be brought to free that child for adoption. And then the additional function that the panel has is whether a specific child should be placed with a particular adopter or adoptive couple. So it's what we call matching. So those are really the key functions of the adoption panel. The assessment report are very detailed, The matching reports are very detailed, but they are individualised as well in terms of, children have their own needs. So we have to really make all of these recommendations and decisions to make sure that that child's individual needs are best met by this, set of couples. So it is quite individualised what's considered as well. And at times, prospective adopters will know quite a lot about a child before that match, is confirmed, because if we're trying to difficult to place young children, we need to talk to those adoptive parents, and they need time to think and maybe discuss with medical personnel, is this the right lifelong match for them? I hope that helps.
No, I think we all appreciate that this isn't a one-size-fits-all, particularly given some of the circumstances that children have actually grown up. They're grown up under the corporate responsibility of the state. A lot of them have grown up not knowing any different. And, I've absolutely no doubt, even from experience within my constituency, that the whole process, albeit very long, is very detailed, because the children are at heart. But when we're looking at legislation and there's a reference to, guidelines or, matching reports and criteria, it's fair enough and reasonable enough for us to ask what those are. So it's not that we're asking, I'm certainly not asking to trip people up, I'm asking because if there are consistent references without any evidence of those references, then that's part of our scrutiny. So, and then obviously, given the volume and the size of this bill, we'll be coming back. Appreciate this is just the principles in the first part, but thanks again.
Okay, thank you. I will just check with clerk and members if there are any other indications at this point. So I'm not seeing members on screen, but I'm certainly not seeing any of the hands raised electronically. And I'll just give that a second or two there. Can I ask, just while I'm checking on that, and we have touched upon the issue of consultation, but could you tell us, Ellis, or any of the panel, around what further consultation plans there are, given the complexity and the dynamics around this bill? What future and further plans are there for consultation?
I think Julie's already referred to it. I mean, there will be may not refer to it as consultation, but there will be ongoing engagement with stakeholders, and and that group of stakeholders is wide. Chair, it is about trust, and it is about voluntary agencies, and it's about children's rights organisations like the Children's Commissioner, for example. So the intention is to continue to engage with all of those stakeholders throughout the process of bringing the legislation forward. Subsequent to the bill, I'm hoping, being enacted, then there will be a process of developing and consulting on a pretty extensive range of regulations to give effect to the bill. So ongoing engagement and future consultation around regulations.
And I accept, and I did hear that you said that there was ongoing engagement with the stakeholders, which is appropriate and is welcome. But will there be a public element? So there's more than just the stakeholders, if you like. There are people who this impacts who might not be engaged in stakeholder groups. So what's the plans, or what would you see as being appropriate at a future date for a wider consultation?
In the future, I mean, no consultation planned during the course of the bill's passage, Chair, but certainly any future consultation will be public consultation on regulations. I mean, we always consult publicly on regulations.
Okay, thank you. And do you have an indication to share with the committee in terms of the cost implications of the bill?
So I think the overall estimated cost over the first 3 years is around 38 million. So it's not an insignificant sum of money, and we have developed an outline business case around that. We can give the committee a further breakdown of that 38 million and what it relates to, and a breakdown by the adoption provisions within the bill and the children's provisions within the bill, if that would be helpful, Chair.
Yeah, that would be helpful. That would be great, Ellis. And I know you've indicated a few other pieces of information to members there that you would send through to committee. So I appreciate all of that. So listen, I want to thank you very much, all of you, for your very, very good presentation in terms of this. I think it was I certainly found it very useful, and your engagement there with the questions and answers and providing the information that we have to date. And I think we will become. We'll certainly be back and forward on this for quite a while and over quite a number of sessions, given the scale and complexity of the issues at hand. But I want to thank you all today and wish you all the best of luck, and thank you for coming to committee today.
Thank you, Chair. Thank you.
Thank you.
Thank you. Okay, members, any other issues or comments there? Following that presentation, and bearing in mind that we will be moving to part 2 of this next week, there has been a number of things which the clerk, I'm sure, has captured there in terms of further information requests.
Just that we've got that noted, have we? Yeah.
Yep. So members content with that? Yep. Thank you. Okay, members, moving on then to the forward work programme. I refer you there to the forward work programme at tab 13.1 of your table papers. Are members content with that, as outlined? Yeah, members content. Thank you. And going to any other business, and there's just one item I want to quickly mention today. I've become aware today that Jonathan is moving onwards and upwards within the committee system here in the Assembly. But I want to thank Jonathan very much for his calm and composed dealing with committee meetings, and your help to me. Nothing has ever been too much trouble, I have to say, and it's always been done very efficiently and very calmly and evenly. So, and I think you've brought that to the committee and been a tremendous help to us. So I want to wish you all the very best, Jonathan. Our loss will be no doubt other committees' gains, but thank you for your contribution to the committee. Jerry?
Just echo those comments. Thanks, Jonathan, for all his assistance and support through the tough committee the last year and a half, and I'm sure we'll see him soon. But best of luck, Jonathan. Thanks.
Yeah, and a very unflappable and reassuring president. I'm sure many a time Jonathan was like the duck going across the water with everything going on beneath. But that goes unseen and uncommented on very often, largely as a result of how well it's done, and that never. So on behalf of the committee, thank you and all the best. Okay, members, any other business? No. Moving then, members, to date, time and place of next meeting. The next meeting of the Health Committee will be on Thursday, 30th of September, in Senate or by Starleaf, as members choose. And can I remind members that the Minister and Chief Medical Officer will attend that meeting, and that meeting will begin at 9 a.m.
We'll meet on Tuesday.
Thank you, Jonathan. We have also indicated that we will need a short meeting on Tuesday. That's correct, lunchtime meeting, and members have agreed to that. And then our next full meeting will be on Thursday 30th in the Senate here or on Starleaf. And I'd like to remind members that the Minister and CMO will be attending the meeting. So we're going to begin at 9 a.m. on that occasion in order to make best use of the Minister's time. So if we could be ready to go sharp at 9, we'll get the most out of that session, hopefully. Okay, members, thank you, and that concludes our meeting today.
This is the Northern Ireland Assembly Senate Chamber programme signed. This is